So thank you for joining me on this final webinar of 2020. My name's Emily Kile. No prepared remarks today. I'm just going to do my best to take questions on the areas in which we practice, which are estate planning, guardianship and conservatorship, all-tax, and probate and trust administration. So I did get a couple of questions in advance. If you have a question, you can type it into the chat box or the Q&A at the bottom. That would be the best thing to do. If that's not working for you, then I think you can press the button to raise your hand, which is also in the information at the bottom, and I'll see if I can unmute you so you can ask your question orally if that's easier for you. As I've always said, I'm not giving legal advice. I don't know all the specifics of your situation. So even though I may represent some of you in lots of other matters, for purposes of today, just please take what I say with a grain of salt so that you understand I'm just answering that one little question and there might be lots of other parts to it. So always seek the services of a qualified attorney when you have an actual legal question. So the first question that I received was, I'm assisting my brother-in-law, who's the executor, in a probate and the distribution of the financial assets of the mother-in-law who passed away. And there are two questions. One is, it says, to be fully informed, does my brother-in-law need to sign a legal document allowing me to participate for reasons of client-attorney privilege? And the second is, if I can provide a brief summary of what one might expect over the process and issues, even though they expect this to be an uncontested distribution. So let me go backwards just a hair. So you typically have to do a probate when you have assets that are only in the deceased person's name. That is, there was no named beneficiary on the account, it's not titled in a trust, and there's no joint owner on that asset. So if I had a CD and it was only in my name, when I passed away, I didn't name a beneficiary, I didn't title it to my trust, I don't have my spouse on there as a joint owner, then my spouse may have to open probate in order to get access to the money. And probate is the process of trying to get assets from a deceased person into living people or over to the charities where the funds are supposed to go. So it's a court process, although typically if we have an original will, we don't need to see a judge, we don't have to have any hearings, but it is, we still have to have documents that get filed with the court. So to answer the first question, which was if your brother-in-law needs some assistance in managing what's going on, if you are not named in the will as a co-personal representative, then what the brother-in-law or other person could do, and it sort of depends on the financial institutions, but typically they could do a special power of attorney to give you authority to assist them in doing certain things. Now, for the most part, financial institutions are going to want the actual executor, the one who's in the will and has been appointed by the court to be the executor or personal representative, to sign off on things. But you could still have authority to investigate, to gather assets, you know, if there's stuff in a storage unit, to be able to enter the storage unit, to interview estate sale companies, to sell the properties that are out there. If you want to be an actual executor or personal representative, typically somebody's going to have to file that petition so that you can become the co-executor or co-personal representative with your relative. And that would give you all the authority to do everything that they could do. In terms of attorney-client privilege, that's between the attorney and the executor. So if the executor is talking to you about things that would otherwise be privileged, like my attorney told me to do X, Y, and Z, and there's a fight later, you run the risk that you can be deposed because that's not your lawyer. And so they have, the attorney-client privilege has basically been breached by that other person releasing information that would otherwise be confidential. So that's kind of how that works from the confidentiality standpoint. So there's a question, and I don't know if you all can see my screen, so hopefully you can see me. Okay, so I'll take that other question next. I thought maybe it would be related to this one. So the next part of it is a brief summary about what to kind of expect as part of the probate. So in general, at least in Arizona, and I understand this is an out-of-state probate, so I'm going to tell you kind of how it would work here, is that a bunch of documents are filed with the court. The court usually takes 3 to 5 days to sign off on the letters of appointment, which are the thing that appoints that personal representative or executor. The letters are the documents. It's a one sheet of paper, but it's a document that then the person can take. I guess maybe somebody can tell me in the Q&A, can you see me? Otherwise I can share my screen and you could see me. Hopefully you can see me. Anyway, off topic. So that the personal representative would have those letters, and that's what they bring to the bank to say, I'm the personal representative, I have access to the account. They would get a new tax identification number. The assets can then go into the account under that new tax ID number. And thank you, Lynette. So they would go into that account with the new tax identification number. Notice is provided to all of the beneficiaries or heirs. And so they would get notice with a copy of the will and a copy of all of the pleadings. So they would know who was appointed and therefore who has authority to do what they need to do. If they want to object to the will, they have a certain amount of time in which to file their objection. And we have to file notice to creditors and publish for unknown creditors. So known creditors, we have to send actual notice to, and we publish for unknown creditors in the paper. Creditors have 4 months to come forward and object, or say that they have a claim that they want for that to be paid. And then the personal representative would need to determine whether it's a valid claim or not, and therefore whether they are going to deny. And then the creditor would have to file a petition to be heard by the court to determine if it's a valid debt or not. And then the next thing that happens typically is that an inventory is provided to the beneficiaries of what all the date of death values are, including all the date of death debts. And we typically then send out a distribution plan under our statute. I think they beneficiary has 30 days to object. And we send out a receipt and release to say, this is how much you're going to get, release us. Of course, you have to do your the final tax return for the decedent, and there might be a house that needs to be sold or other property that needs to be sold. So even though you can open and close a probate within the 4 month, after the 4 months has run for your creditor's claims, usually probates are going to take longer than that because we have these administrative steps and potential debts out there and assets that can't just be liquidated and passed on. So that's kind of the general process. And of course, there's all kinds of other bits. There might be personal property and family members need to come in so that they can pick what they want. Or maybe that stuff gets sold and you have an estate sale company. Those are kind of the first things that you're going to do, which would be notice to creditors, notice to the heirs, and then go from there. So I hope that that's helpful to answer that question. The next question I got, and then I will go to the questions you all are posting for me. Thank you. Is person works for a hospice organization. They have a patient who has dementia, who has a primary medical power of attorney, who's the spouse, and an alternate who's the son. The spouse is having some memory issues and is not wanting to defer decision-making to their child. So the question is, what happens in order for the medical power of attorney to roll it over to the son? Is there a formal process or what needs to happen? That is a fantastic question because life is messy. And so we draft documents that seem super clear with nice bright line delineations, but then people are in the mix of that and they don't behave the way we think maybe they should behave. So I would say in this instance, typically there's a definition of incapacity even for the agent. So if there's a doctor's letter saying that mom as the healthcare agent does not have the capacity to make healthcare decisions, typically that's what the doctor, facility, or hospice worker should be looking for, is some medical evidence that that person is not able to make those decisions anymore because of their own incapacity. Obviously, it would be best if she would be willing to admit that this is hard and do either sign a declination to serve or resign as the agent. And then by doing so, the next person in line would be able to act. In the worst case scenario, when maybe the person really can't act for the best interests of their spouse but are unwilling to admit that they can't do it, the son may have to petition to become guardian of the dad who's the demented patient, and maybe even of mom who's unwilling to see that this is too hard for her and her capacity is such that she can't do this in a meaningful way. Of course, all that requires a doctor's letter. So getting mom to see the psychologist or psychiatrist or social worker so there can be a diagnosis and some explanation of what's going on with her is helpful. But again, life is messy. And so my hope in this situation is that at least mom will allow son to act, and maybe they can go talk to the doctors together so that rational decisions can be made without too much controversy for what's going on within the family. So I hope that is helpful. So question that came up is, my dad has a wife that's incapacitated and on hospice. He tried to get her removed off the deed. The title company declined. Is it possible to remove her from the deed? He has a declaration of incapacity and a general durable power of attorney. Another fantastic question. Thank you. So technically, the answer would be, if the power of attorney doesn't give him the authority to act in a self-serving manner so that he transfers the property all to himself, most title companies are still going to deny that transfer, even if he has a power of attorney that would otherwise give him the right to make the transfer. So technically, under the power of attorney, if it says he can transfer real estate, he should be able to do it. I'm just telling you that my experience has been, unless the power of attorney says that the agent can transfer real estate to anybody, including themselves, title companies see that as self-serving and have an issue with it when you go to sell the property, and they need to issue title insurance to the buyer of the property as to whether in fact he had the legal right to transfer assets to himself. Again, there's always the option to go to court, which I understand is expensive and time consuming. But if the title company is unwilling to allow that to happen because they won't issue title insurance, then he can go to court for single transaction authority and explain whatever the reason for this is, whether it's to protect the asset for all tax purposes, or maybe he needs to get it sold. And then we've done this before in these instances, and we need that single transaction authority to be able to sell the property or get it transferred to where it needs to go. Next is a question about whether there are online notaries available in Arizona and how does one locate an online notary. So my understanding is the answer is yes. The other part of that is there are only certain documents in which an online notary is a legal notarization. But you should be able to go to the Secretary of State's website where all the notaries are listed. And I believe there is a section of those that include the electronic or online notaries. And so you should be able to find them that way. If you need an online notary, of course, there are mobile notaries. I understand with COVID, that's not perfect. But if somebody needs somebody to come to the home, there certainly are that, and you can Google that very easily to find those. But I would look at the Secretary of State's website for online or electronic notaries. Okay. So I'm getting the questions at the same time you are. So I'm going to do my best here. So it says, Karen is the mom. She's medical power of attorney, guardian, etc., for her special needs daughter who's 30. That's a little confusing because typically if you're guardian through the state court system, then we don't have a medical power of attorney. So I'm just going to assume that she has some authority under either a document or a court order. When her daughter ends up in the behavioral health hospital, Karen can never be the main contact and liaison for her daughter. They say her guardianship said something about the fact that Karen cannot involuntarily admit the daughter, which she wouldn't do, but in the past her daughter would have an episode, be admitted, and then Karen has no rights. Am I right in that I believe there is a behavioral health power of attorney that families need to have in addition to the medical power of attorney? So now it's clearly a guardianship. So guardianships allow the guardian to have the ability to make all healthcare decisions. But if you need the authority to make inpatient psychiatric decisions, then you would have to have a guardianship with mental health powers. And that would give you the authority to make those mental health decisions. The statute says that under Title 36, which is typically if the state has admitted the person because they're a danger to themselves or others, they're supposed to work with the Title 14 guardian, which is the guardianships that our office does with the probate division. But if the daughter says to her social worker or case manager, do not talk to my mother, they still may not communicate with you, even when you're the guardian and even when you're the guardian with mental health authority, although I've seen that less recently. If a person is under guardianship and they have mental health issues where they will need or could need inpatient mental health treatment within 12 months of the date of appointment of the guardian, as I said, you can get that extra mental health authority. So you could admit the person against their will, that is involuntarily, and it should give you that extra authority to be able to communicate with the inpatient provider. If you are a competent adult, which by being under guardianship, we assume that person is not, yes, you should sign a mental health power of attorney or have a healthcare power of attorney that includes mental health authority. That is an addition within the statutes here in Arizona. So I hope that is helpful to Stacy. Next question. In a special needs trust where a sibling wants to be involved with the trust but is concerned about the level of work it would involve, could you please compare and contrast the sibling being a trust advisor with the right to remove and replace the trustee, the sibling serving as the trustee with help from an assistant trustee? Are there concerns, advantages, etc. to each approach? Being a trustee, whether of a special needs trust or not, is a big job. So you always want to pick somebody who is going to have the time, energy, emotion, everything to be able to manage that. So a trust advisor, or sometimes we call them the trust protector, that is a person who doesn't have a fiduciary obligation, so they can't be sued for messing it up. They typically have the authority to choose another trustee if they feel like the trustee that's there is uncooperative, hard to communicate with, making bad decisions, poor investments, whatever those things might be. They would also typically have authority to review accountings and investments, meet with the trustee on a regular basis to review the goals and what's going on and come up with a budget, without having the fiduciary obligation to make sure that happens or that the investments are appropriate. So absolutely, the less level of work would be to be a trust advisor or a trust protector rather than a trustee. The question asked, could they get help from an assistant trustee? We don't really have assistant trustees. We have co-trustees. We have successor trustees who take over if we can't act. So you could have co-trustees. One of the issues with being a co-trustee is you still have a fiduciary obligation. So if you mess it up and do something wrong, you can be sued by the beneficiary. And if you have co-trustees, I always worry if they have a difference of opinion, whose opinion counts. So if they don't get along, they disagree about whether that's an appropriate budget for that person or whether buying that car or a new computer makes sense. If we have to resolve those kinds of disputes on a regular basis in the court system, then we were spending a whole bunch of money and we've picked the wrong trustee. So if they don't want a lot of responsibility, but they want to know what's going on, then being a trust advisor or trust protector would be a better plan. And so I have another question. So one that was just handed to me, but I want to get you guys who are on here as well. So it says, I'm the executor of my parents' estate. My name is on their checking and savings account, and I'm the beneficiary on life insurance. Upon their death, do I have to consult with a probate attorney to divide resources and assets to the other siblings? So typically when your name is on an account as a joint owner, not just as a signer, not just as an agent under a power of attorney, but as a joint owner, when that person passes away, Typically, that money is all yours. Your siblings, I suppose, could argue that mom and dad did that out of convenience and they had no intent for you to get the funds. We like to say in the will, whether it's for convenience or those beneficiary designations and joint ownership are intentional, and that therefore the joint owner would get the assets. That is the presumption. When you add somebody as a joint owner, not just a joint signer, that they will get those assets upon death. If you are named as the beneficiary on the life insurance, those funds are yours to have. I don't even know, other than an argument that you unduly influenced your parents, that you acted poorly, that they were demented and had no idea what they were doing, that you forged the signature. All of the bad acts, if those occurred, could be a contest from the siblings. But if those aren't the facts, I don't know under what theory somebody could argue against you getting the life insurance. You would only have to consult with a probate attorney if you need to open something with the court or some nastiness occurs and you need some help and some legal counseling on getting through that process. Otherwise, if you're a joint owner beneficiary, typically you're going to get those assets. So, Neil, I'm going to read your question. You have your hand up. I'm going to assume that if I answer this question, that was what your question was. So I'm going to lower your hand, and if I don't get it right, you'll let me know. So what are the basic liabilities, civil, criminal, financial, for the guardian? So a guardian is supposed to act in the best interest of the person that they are guardian over. So if that person doesn't have a driver's license and you give them the keys to your car, you've breached your obligations to them and probably the community. That's not a good thing. Typically a guardian doesn't really have access to funds. So your financial liability again would be if you do a bad thing in your role as guardian, then somebody I suppose could sue you because they got injured by the fact that you gave the keys to the person that you are the guardian for, and you know that their license was suspended and they should not be driving. You have acted kind of outside the scope in a reckless manner. So that's a problem. You don't otherwise have personal liability, at least you shouldn't, pursuant to the statute. So if the person you're guardian over runs up a big credit card bill, but you're not a guarantor of the debt, that's not your debt. You don't have to pay that back. If the person goes and buys a car and they sign off that they're going to pay it, as guardian, you're not responsible for their personal debts. Make sure when you sign things, you sign as guardian, not in your individual capacity. Or if you're the conservator, you sign as conservator. Or if you're the agent under a power of attorney, you sign as agent. So Emily Kile as agent for Jennifer Score, instead of it just being Emily Kile for Jennifer, right? I want to make sure that who I'm signing with understands what the role is that I have in that relationship. So going back to one of the other questions, and then I'm going to go to the question that I just was handed. So in the probate case I was talking about at the beginning, it says, can those assets in which beneficiaries are designated be distributed without waiting the 4-month period? So the assets on which there are beneficiaries named are not part of the probate process. So the executor shouldn't even be involved in any way, shape, or form with distributing those assets. So if there's an IRA or a life insurance policy and it says Emily Kile, I should contact that life insurance company or that IRA company and let them know so-and-so died, I'm the beneficiary. They'll send their form, condolence letter, ask for a death certificate, and then I can respond to that and to fill out the forms and get the money. If it turns out that there are insufficient assets in the probate estate to pay the creditors, the executor could possibly, depending on what kind of asset it is, could possibly pull those non-probate assets back into the estate so that they could pay the debt for the debts that are out there. There are some limits, however, on on what assets are available to pay creditors. So typically life insurance, if there's a named beneficiary that's a family member, is not available to pay the creditors of the decedent. The same with annuities and potentially retirement accounts. So it may be that even if there's not enough money, that those assets aren't going to be used to pay those debts. This says, my father passed away as a resident of another state with his primary residence in that state. I've opened a probate in that state, and he also had a house in Arizona. Do I have to open probate in Arizona also? So typically the answer is no. You can do an ancillary probate in Arizona. And so there are just some different documents that need to be filed with the court, along with your letters of appointment in the state in which you were appointed. And that all typically gets recorded with the county recorder so that you can deal with the residents or other assets that are located in Arizona. Most states have an ancillary probate process, although not all, but definitely Arizona does. So you shouldn't have to start from scratch and open a whole new probate in Arizona, which should reduce your fees and your responsibilities as well. So when stepping in as NOK, I don't know what that stands for. The person is incapacitated. How do I step in to pay their bills with their finances? What steps do I have to follow? So I'm gonna, since I don't know what NOK stands for, I'm gonna say the person's incapacitated. If you are the agent under a power of attorney, you have to follow what the terms were. That is, do you have to prove with 2 doctors' letters that the person's incapacitated, 1 doctor letter? What's the system there, so to speak? Oh, next of kin. Thank you. So just by being next of kin does not allow you to pay somebody's bills or access their money. So if they're still alive and incapacitated, if you have a power of attorney, as I said, you'd have to follow how they're determined to be incapacitated. And then you would provide the power of attorney document along with the letters from the doctors to the financial institutions where the money is kept. And then you would be able to access their funds so you could pay the bills. And of course, you would want to keep good accounting records so nobody can accuse you of stealing. But if you're just the next of kin and you're not already on that account, your next step only would be to file for a conservatorship so that you can access the account, because the banks or other financial institutions would otherwise not allow you access. Or if you're trying to sell real estate, the title company would need a legal document to prove that, in fact, you have the authority to deal with those assets. For an adult with intellectual disabilities that's not under guardianship, can the parents put both financial and healthcare power of attorney in place? That is, can the client sign a document that transfers power of attorney to their parents? So if the person is an adult and they have the capacity to understand a power of attorney and they're not under guardianship or conservatorship, they absolutely, like any other adult over the age of 18, can sign powers of attorney to appoint somebody to make decisions. Remember that a power of attorney does not remove the other person from having the authority. So, for example, I have my estate planning done. Hopefully, that's what I do for a living. And so I have my husband listed to be my financial power of attorney. That doesn't mean that I don't still have access to my assets, that I can continue to pay my own bills. It just means that he also would have authority if it's effective immediately, or if there's an asset that's only in my name, that CD I talked about at the beginning, that he should have access to it if I became incapacitated, if that's what the document says. So if your adult child with developmental disabilities or not, that means you could do things for them, but it doesn't mean they can't still act for themselves. That's part of having capacity. The same thing with a healthcare document. So if you're the healthcare agent, your child still has a right to say what they want. And if they have capacity, they can override what you say. They could tell the doctor, don't talk to my mom or dad, even though you're listed on that healthcare document, because typically that only goes into effect upon incapacity of the adult. That's what makes guardianship different. When you're under guardianship, that person has lost the ability, the authority under the law to make those decisions. The guardian basically stands in the shoes as if they're a parent to a minor child. The other thing about a power of attorney is it can be terminated. So they could either, if it allows for written or oral, whatever it says, they could terminate the power of attorney when they don't like you anymore and make somebody else the agent. With a guardianship or conservatorship, you can't do that. We need a court order to change or terminate that guardianship or conservatorship. But of course, those are only useful when we have somebody who's incapacitated, because that's how we define when we can get a guardian or a conservator appointed. So I hope that's helpful and answered those questions. I don't see any other questions. I wanted to talk about two other things for those who want to stay on with me that are questions that come up all the time. So one is, how do I transfer the guardianship? We're moving to another state, or we're moving to the state of Arizona and I'm already guardian over my person. So the short answer is we're part of the Uniform Guardianship Act. So typically we only need to file, unless you're conservator or you have mental health authority, we don't have to have a hearing. We just file in the letters and orders from the other state and an order from that state saying it was okay to transfer. And then we get an order here saying, yes, we're going to accept this matter, and you're appointed. Letters are issued and you didn't have to have a hearing. If it's a conservatorship because you're managing money or you have the authority for inpatient psychiatric treatment, then we have to have a hearing, because we have all kinds of other complexities, like we need court-appointed counsel and we need to figure out accountings for the money and bond and restrictions and all of these other more complicated matters that we can't just do on the paper. So that's how transfers work. The other thing, which I didn't realize was a question, but lots of people think if they have a trust, they're done. You have to remember that the trust has to be funded, meaning that you have to change title to the assets into the trust in order for the trust to work later in the way you intended. So I think of the trust as, I build the house, but you've got to put the furniture in and turn on the power. So I can do a deed that you would sign to transfer real estate to the title of the trust, the name of the trust, but I can't go to the bank and transfer your bank accounts, and you wouldn't want me to, right? Who wants their lawyer to have access to all of their accounts to retitle them? What if they're a bad person? It doesn't work like that. The bank is only going to listen to you. So instead of my bank account saying Emily Kile, it says Emily Kile, trustee of the Emily Kile Trust, right? My house, the deed to the house that's recorded with the county says that it was transferred from Emily Kile to Emily Kile, trustee of the Emily Kile Trust. If you don't retitle your assets in the trust and you pass away, and we're where we were at the beginning of the conversation today, which is there's no joint owner, there's no beneficiary, and we've just said it's not in the trust, then somebody will still have to file a probate and get those, collect the assets in the estate, and then open a trust account and move the assets into the trust. So now we have a two-step process, when the part of the goal of the trust was to avoid having to file anything with the court. So be conscientious about that. You cannot retitle a retirement account, IRA, 401k, 403b, whatever kind of retirement money, in the name of the trust while you're alive. It always has to remain in your name as the wage earner when you're living. You can name a trust as a beneficiary of those plans. Now, whether you want to or not for tax reasons is totally different, but you can transfer almost anything else to title it to the trust. Checking accounts, savings accounts, money markets, investment accounts, stocks, bonds, mutual funds, all of that other stuff can be titled to the trust. Another question that comes up, and then if I don't have any others, I promise to stop talking, I just get excited, is that just because you have a will doesn't mean you avoid probate. A will is the expression of, hey, if you have to open a probate, this is who I want to be my personal representative. This is where I want my stuff to go. So the will expresses where that goes. The whether you need probate or not is completely dependent on whether there's a joint owner, whether there's a beneficiary named, whether there's a trust as the owner. The exception would be if there's only a small amount of money, less than $75,000, that fits into those categories. We can do something called a small estate affidavit, so we don't have to open a full-blown probate. You sign the affidavit that says I'm the person who's entitled to the money. You present that to the bank, and we hope that the bank pays attention to you and gives you the funds. And then they can be distributed pursuant to the terms of the will, or whoever the heirs are that are entitled to receive the money. If you're in a second marriage, or I should say, if not all your children are in common with your spouse, you want to be very conscientious to do your estate planning, because there are rules about who gets your half of the community property and who gets your half of the sole and separate. And your spouse might not be very excited because your kids are going to get your half of the community assets. So they're going to lose half their money. So be conscientious if all your children are not in common, to make sure that your stuff's going to go where you want it to go. One other question, it says, when a house is sold upon death, who's responsible for paying the taxes? So when the house is sold, the title company will ensure that any liens are paid off, any back taxes are paid off, any other debts that are filed against the house are paid before the assets are distributed to whoever the beneficiaries are. The personal representative is responsible for making sure the final income tax return for the deceased person is filed. You can't close your probate until you affirm to the court that all of the taxes have been paid and appropriate tax returns have been filed. And Arizona does not have a death tax. So you have to have an estate worth more than about $11.5 million before there's any estate tax. But you might have income taxes if you're going to inherit, for example, an untaxed retirement account. So there isn't just tax because somebody died. It just sort of depends on what the circumstances are. So I think we set this for half an hour, and I have been going on for 37 minutes. So I talk really fast because I get excited. I don't see any other questions or hands raised. So I think that's all we have. I thought this was super fun. I hope it was helpful to those of you who are listening. And so we'll do the same thing as our last webinar for next December. We'll be doing these webinars on one Wednesday every single month. We have a great lineup. And I so appreciate you all participating. You're just wonderful. And I just feel so incredibly honored that you come and listen to me and that I have the opportunity to work with all of you. So I wish you the best in 2021 and hope that someday we can see each other in person again. So all the best, take care, and thank you so much.